Good. I'm going to
start. So, hello and welcome. My name is Bradford Sussman, and you're watching Media Reporter. Today we're talking with Professor Heather Cucolo, who teaches the sex offender course at New York Law School. Professor Cucolo.
Hi, I'm glad to be here. Thank you.
First of all, I'd like to ask you about I'd like you to explain your specialty and just talk about how you got involved in this area of law.
Definitely, absolutely. Well, when I was in law school, I had a strong interest in criminal law, constitutional law, and then really began to explore aspects of mental disability law. And sort of with my interest on sort of those three areas, when I decided in terms of what I wanted to do in practice, learning about this area of sex offender civil commitment was really interesting to me because it afforded me sort of this intersection of the three, of constitutional issues, of understanding the background, the criminal law issues, as well as incorporating significant aspects coming out of civil commitment law and the science and the medical information that clearly is part and parcel of it. Mm-hmm. So I began litigating in New Jersey for the state, and specifically what I did was represented individuals who were deemed sexual violent predators and who were being petitioned, sought for civil commitment after they have either completed a criminal sentence or for one reason or another kind of fell under the purview of the Attorney General for individuals that should be contained in a civil commitment setting, and that they had some sort of prior act or crime that satisfied the statutory requirements for that. So basically my experience was defending individuals when they were in court and being initially civilly committed, and then throughout the process of their review hearings, if they were civilly committed.
Now, I know you get asked this all the time, but I think an interesting place to start would be why do you defend these people, or what causes you to want to basically work and focus on sex offenders?
Yeah, and certainly, I mean, that's a question that I'm asked often, and a question that I do understand, especially for someone who, again, is not really familiar with kind of the intricacies of this law and this area, and certainly is sitting back. And when you hear the term, sexual violent predator, you automatically are going to envision this heinous, monstrous individual who has committed horrific acts against children, let's say. I mean, I think that's sort of the idea that comes to mind. And certainly, the nature of the acts that these individuals commit, which absolutely is not exclusive to children in any sense. It spans a whole slew of types of sexual offenses and assaults and whatnot. But certainly, the act itself can be disgusting, distasteful to me, not something that I would at all have any positive feelings towards. But again, coming from a legal perspective, coming from an attorney perspective, I look at this area as whether or not it is appropriate, and whether or not it is constitutional, and whether or not it protects human rights. And my belief is specifically and especially when we're talking about the civil commitment of sexual violent predators, that it absolutely violates constitutional protections, and it absolutely infringes on individuals' human rights, and that in fact it is something that is important to combat in the sense of making sure that our laws are being properly executed and that rights are being upheld for everyone, regardless of the crimes that they have committed and the type of individual that they might be.
So when you're defending people in and I'd like you to discuss more of the specifics, when you're defending people in a civil commitment hearing, do you consider yourself advocating for a client within this legal framework, or do you consider yourself someone who's trying to work against a legal framework that you might not agree with, civil commitment?
I think absolutely both. Obviously, in the civil commitment setting, I am not defending this individual against the criminal act that they committed. That has already been adjudicated. Either they were found guilty. There are a number of ways, of course, that it satisfies the statute that is put forth in order to civilly commit this individual. But I am not defending their crime or their actions. But what I am advocating for is their right to not be further contained by the state and by the government. And it is because I disagree strongly with the laws that have been put in place. And I do not find justification in the basis that has been put forth for them to have, for the development of these civil commitment laws.
So just to back up a bit, could you discuss just the constitutional framework and how these civil commitment laws are enacted in both, on a local basis in the state and nationally? Absolutely.
So what we deal with today are sort of what we have termed the new generation sex offender laws. Sex offender civil commitment, in a sense, has been around for since the early 1900s. Well, not sex offender civil commitment, but sort of laws enacted to attempt to control this population and deal with these individuals has been around since the early 1900s. What we saw sort of in the 1970s with the sexual psychopathic laws, and the idea here was the focus on, instead of punishing these individuals criminally, what we were going to do was try to treat them. So it was more focused on rehabilitation. What happens, though, is that these laws fall into disfavor because basically it is seen that the treatment really is not effective. And that sort of the idea of the sort of sexual psychopath and the idea of the psychopath in itself is questionable as whether or not the individual actually is capable of being treated. But there were a number of dynamics that went into play. But what happens then is sort of as a catalyst from a couple very high-profile sex assault cases. We have the Earl Shriner case, a couple of other situations that had gone on. There was a movement and a push on a political platform to once again sort of redesign this civil commitment idea of a way to contain individuals that we feel are too dangerous to be let out into society. And of course, the pivotal case that we get to is the case of Kansas versus Hendricks, which is this U.S. Supreme Court case coming out of Kansas and based off of an individual named Leroy Hendricks. Now, at this time, Washington State actually is the first state to really put forth a statute that is designed to civilly commit individuals. And Washington State was sort of struggling with their statute, struggling with support for it, struggling with expenses and whatnot. What happens, though, is Kansas, which had also soon after put forth a statute now, has a case that has made it all the way up to the Supreme Court, and that case is the Kansas versus Hendricks. Leroy Hendricks, who is a pedophile, a repeat offender, someone that that freely admits his sexual attraction to children, someone that has repeatedly maintains that he cannot control himself and that if he is to be released, he's going to find more victims. And so with this sort of perfect specimen, so to speak, what happens is it goes up and the question in front of the Supreme Court really, you know, is this punitive? Is this a violation to keep this individual, Leroy Hendricks, after his prison sentence, and then to move to civilly commit him? Is this punitive, though? Is this a further extension of punishment? Does it violate ex post facto or double jeopardy? Is it constitutional? And the Supreme Court takes a look at it and sort of in a nutshell determines, no, that the statutory scheme is civil. It has a civil basis. The idea here with the first and premier goal is to protect society, is to contain this individual and other individuals like him such that society is safer now and such that this individual cannot be a danger. And that is based on the fact that it is maintained that his risk to reoffend is high. So the Supreme Court agrees that this is a civil scheme and that therefore it is constitutional, it can be constitutionally upheld. Now the Supreme Court of course maintains that certainly it could very easily slip into the realm of punitive detention if it, you know, doesn't offer certain things. And one of the things that it must offer is a form of treatment or some aspect of treatment such that the idea here is that this is a condition, this is a mental condition that requires or that should be given treatment. Now, what's important here is to understand what we mean when we talk about this mental condition. And when we think of civil commitment, general civil commitment outside of the sex offender realm, what we're looking at is we're looking at individuals with a mental illness. Now, what happens is when we talk about sex offender civil commitment, these individuals very rarely can be diagnosed with sort of a full-blown mental illness. What they can be diagnosed with, though, is a mental abnormality and a personality disorder. And all of these things are defined in the Diagnostic and Statistical Manual, which is used by psychiatrists and psychologists in terms of determining what different diagnoses can be given. But the key distinction here is that the Supreme Court finds, you know, that this is sufficient, that this idea of a mental abnormality which predisposes this individual to commit future acts of sexual violence is acceptable, and it's appropriate to civilly commit this individual as long as they fulfill the statutory requirements and as long as it is supported by medical testimony, i.e. a psychiatrist or a psychologist that can come in and say, yes, this individual has this diagnosis, and this diagnosis is connected, is sufficiently linked to their future offending behaviors.
Mm-hmm. And how important is an understanding of psychiatry or psychology to the work you do? And are lawyers really, and these hearings, et cetera, courts, are they equipped? Is the statutory framework effective in sort of dealing with the psychiatric and psychological issues?
I mean, this area is not unlike so many other areas in the law. You could take medical malpractice, for example, and certainly if you're going to be a plaintiff's attorney, you need to truly have a working knowledge and an understanding of the medical aspects or information that you need to know in order to be effective in your case. Same goes certainly for this area, whereas for cross-examining or direct examining experts in this area, you really as an attorney have to have a very strong working knowledge of these diagnoses, of the treatment, of the medical background that sort of surrounds these issues. And certainly you do that by studying, you do that by learning, you do that by reading, but also a lot of it is facilitated as well by possibly your own defense experts or experts that you might hire that can educate you sort of on the intricacies of this area.
So how does the current understanding of the quality and effectiveness, or even the possibility of treatment for sex offenders, how does that play into the idea of civil commitment?
Well, first, I think there has been a lot of backlash against these civil commitment statutes. One primarily being sort of the exorbitant cost that they have put forth. But in terms of the academic field, on both the legal side as well as the psychological, psychiatric side, is questioning the treatment that is offered and whether or not it is sufficient, whether or not it is actually has any sort of effect on minimizing or affecting risk. And the treatment, I guess I should say, that is most commonly administered, and again, remember, we're not talking about a mental illness where a lot of the times, if we, let's say, talk about schizophrenia, other types of disorders, paranoias and whatnot, where there is an actual medication that can be offered. We're not talking about that when we're talking about sex offenders. What we're talking about are mental abnormalities or personality disorders. These are things that are not primarily treated with medication. Now, we can talk about chemical castration, which I'll talk about in a second, but not primarily treated with medication, and therefore the premier mode of treatment is cognitive behavioral treatment. And certainly, cognitive behavioral treatment, it can be effective, is very effective in many areas, but whether or not it's effective for sex offenders and whether or not it's effective in reducing risk or in changing their sexual preference or their mode of interaction is questionable. And I think, therefore, it's important to look at these issues when we are considering the fact that we are locking up individuals indefinitely without really any strong, firm foundations as to whether or not we're making any type of impact on their treatment or on their rehabilitation.
I would think that, does this cognitive behavioral type treatments, do they require to be effective a sex offender who really wants to change or wants to, I would imagine, but maybe you could address that.
No, absolutely. I mean, that's a great point. And of course, in order for there to be any type of growth or movement or change, the individual has to be amenable to the treatment and has to want to put forth the effort. Not only want to put forth the effort, but have the capacity to put forth the effort. And we have a whole nother subset of problems, which are individuals that are sort of in this type of civil commitment setting in this institution that may have significant developmental disabilities, cognitive limitations, and whatnot, that kind of brings into it a whole nother issue and problem of whether or not they're actually going to have the ability to benefit from this treatment and how long, in fact, they're actually going to remain civilly committed, which, you know, likely outlook is pretty much forever.
Mm-hmm. Now, prosecutors, when they're approaching criminal cases, I know have all kinds of pragmatic and ethical concerns in terms of which cases they choose to prosecute. In your opinion, how are civil commitments approached by the agencies that prosecute those cases, and is it the appropriate approach to these cases?
Now, at this time, there are 20 states that have a civil commitment for sex offender statute, as well as the federal government that recently sort of upheld a civil commitment scheme under the U.S. versus Comstock case, and that's sort of embedded under the Adam Walsh Act, which I think most people are familiar with when it talks about sort of community notification and registration, and the Sex Offender Registration and Notification Act that comes out of it. So when we're looking at this sort of idea of individuals who, wait, I'm so sorry, wait, your specific question was?
Just how the prosecutors
right, I'm so sorry.
select the cases for
exactly.
the civil cases, because, you know, taking into account how prosecutors typically choose, you know, which criminal
Absolutely.
cases to prosecute.
So when this was put forth, the idea was it's supposed to target the worst of the worst, the most dangerous, those that have the highest risk. And it's really sort of a state-to-state assessment. And certain states are going to handle sort of their weeding out or their determination as to who they're going to choose for possible civil commitment. For instance, I can say, you know, practicing in New Jersey recently has taken sort of a stance where they're going to kind of look at everyone, and that they are potentially going to, all individuals that satisfy the statutory criterion, especially those that are coming out of prison, are going to be referred for evaluation to determine whether or not they meet the statutory requirements. And at that point, I think they sort of leave it up to the experts, the psychiatrists, psychologists evaluating the individual, to kind of make the call as to whether or not they feel that these individuals should be subject to the civil commitment process. Now, there's so many layers to this, and this calls into play a number of problems. One being, you know, the merging of the legal definitions and basis for civil commitment versus the medical, psychiatric definitions for civil commitment. That in itself is a huge problem. What else is a problem here is that these individuals that are evaluating sex offenders, their jobs, their livelihood, oftentimes is very much dependent on the success of these civil commitment institutions. So questioning whether or not there's some sort of bias, questioning whether or not there's a ability to be more discriminating comes into play. Kind of overarching on all of this is the idea of, can we actually determine future risk? So one thing to answer your question is we've moved away from only looking at the worst of the worst. Absolutely. You know, when you look at states that have 400 individuals in civil commitment, or states that have thousands in civil commitment, we're absolutely moving away from that kind of specialization of the worst of the worst. So that's sort of the one thing. But the other thing is we're doing this based off of an idea that we can somehow, to some degree of certainty, predict whether or not this individual is going to reoffend. That in itself has been time and time again challenged, and different studies have proven it to be completely impossible to actually, to any real significant degree, be able to tell who is going to reoffend and who isn't going to reoffend. And therefore, the whole entire sort of platform that this is based on, which is future risk and dangerousness, in itself is not valid, and has not been validated appropriately.
So is there a way that these programs gauge their success, or is there a way to gauge success, or is it all just conjecture?
You know, up until now, I don't think that there has been any real push for them to have to gauge their success. I think that the general public, just knowing that sex offenders are off the streets in their mind, or that these individuals are just out of their communities or out of, you know, their purview, I think is sufficient enough. And and there is no way to gauge success. And for the most part, many of the states have, released a very, very small handful of individuals. Some states, such as Minnesota, Washington, have released almost none. I think Washington released 1, Minnesota has released 0, and in fact, very recently now there has been some litigation that has come up in the courts challenging the fact of whether or not there's any reality, any real basis for this commitment, for this treatment, because of the fact that no one has been released and there has been no rehabilitation. But the success of the programs, I don't think, is something that people look at. I think it's more so that they exist and they contain offenders. But whether or not they have any ability to rehabilitate them, any ability to assist them in becoming productive members of society, I don't think has been looked at. And in my experience, is not something that's a focus of these institutions.
Based on the legislative framework that's developed and out of the Supreme Court cases, what is sort of the typical makeup, or can you make generalizations on the makeup of a civil trial versus a criminal trial? What kind of constitutional protections exist? Can you compare the just a typical criminal trial and a typical civil commitment trial?
Sure. I mean, one, I think, the most important distinctions to look at is the rules of evidence that occur. In these civil commitment hearings, the rules of evidence are very lax in the sense that hearsay is offered in, offered up, and relied upon by the experts readily, and is allowed to do so because it is believed that prior uncharged crimes, statements of victims that were not adjudicated in court, and all of these things go into sort of the building of the expert in making their determination and diagnosis. And all of this is allowed into court. All of this is allowed in to be considered and determined. Now, usually it can't be relied upon as fact, let's say by the fact finder, but nonetheless, it is relied upon by the experts making the determination about risk. So that in itself, when we look at the rules of evidence. Other situations such as self-incrimination, the right to take the Fifth Amendment, that is not, that's not allowed for. Certainly it's a civil case. They have no, right to remain silent. But, that's only sort of just that small little subset of in court. More importantly, though, is in their treatment groups and what goes on behind the scenes, all of the information, everything that they discuss in treatment, everything that they talk about is allowed to be put into evidence. So there is no confidentiality aspect either. So everything that is said in treatment groups, everything that is sort of discussed about their crimes, about their past, and they're encouraged to be open and free, but all of that comes into evidence and can and is used against them in maintaining their civil commitment or in initiating their civil commitment.
So we're running low on time here, but just bottom line, what impact do you think civil commitment laws have on recidivism?
Very little. And I think that if you look at the studies and you take a look at sort of sex offenses and whether or not they have been minimized, whether or not civil commitment has any real impact on our safety, on our protection, there is nothing to show that it has. And therefore, I don't think, A, that we can effectively determine risk. And I don't think, B, that we focus necessarily on the right individuals, and civil commitment certainly does not do that. And then I think, C, again, it's something that infringes significantly on human liberties and human rights. And the benefit of it, I think, has yet to be seen and has yet to be determined. And therefore, we have to decide whether or not we're willing to destroy human rights, human liberties, with an institution that has done nothing thus far to really make us safer or to protect our children or our women or our community.
Well, thank you, Professor Cucolo. I really think we've only begun to scratch the surface of this issue, but we're out of time. So thank you for watching Media Reporter, and stay tuned for the next one.